conference is being live streamed onto our website, and there is interpretation into English, French and German. For the journalists on the call, please select your language under the interpretation option in Zoom. I would also ask you if you could to please show your name, make sure that your name appears in the Zoom, in your Zoom account as well. And with that, we will start this press conference. Esther Lynch, General Secretary of the European Trade Union Confederation.
Good afternoon. Good afternoon, and thanks for being part of the press conference today, and indeed to thank the interpreters and everybody who's working with us to make this facility available this afternoon. Today's landmark ruling from the Court of Justice confirms that the EU Minimum Wage Directive is on solid ground. The Court has made it clear that Europe can act to promote collective bargaining, and that the right to collective bargaining is part of the fabric of European law. The directive's core, the fight for adequate minimum wages and the support for collective bargaining, rests on a firm legal foundation. After this ruling, there can be no excuses. The directive is valid, binding, and now must be fully implemented. The deadline for the transposition of the directive was already the 15th of November 2024, yet a number of member states have still not done so. So we're calling on those member states to stop the wait and see and to immediately take action to meet their obligations to fully transpose the directive. All member states all the measures promoting collective bargaining remain completely intact, including the obligation for member states to have an enabling environment for collective bargaining, including effective protection for workers against reprisals when they choose to exercise their right to collective bargaining. The obligation for member states to adopt national action plans if they have less than 80% of the national workforce covered by collective agreements remains in place. That's 18 member states who have less than 80% collective bargaining coverage, but of those, only 4 countries have so far put forward action plans. So again, stop the wait and see, sit down with the social partners, include trade unions, and get those national action plans developed. The deadline for these action plans is the end of 2025, so the clock is ticking fast, and it's important that member states take that step. Our message for workers and their unions in Denmark and Sweden is that the ruling confirms the system is to be protected. It's true that the court has removed one article from the criteria on how to measure adequacy, but it has kept the substance, the principle that minimum wages must ensure a decent standard of living. And the key benchmark, 50% of the average wage and 60% of the median wage, remains in place. That is one of the key drivers which has been hugely influential already in increasing statutory minimum wages throughout the European Union. That threshold of decency still stands and must guide wage setting. The trade unions will push for that, will encourage that, and will keep calling for that as a threshold of decency below which no statutory minimum wage should fall. The judgment gives us clarity, but it also creates a challenge because it has removed a number of adequacy criteria. It's annulled them from the directive. But what that means in our view is a need for guidance and coordination from the Commission in the form of a recommendation to help member states to deliver their obligation, which remains in place, which is to ensure that their statutory minimum wages are adequate. That was not removed by the court. That's why we're very clearly calling on the Commission to issue a recommendation to support member states in their implementation of the directive by providing a framework of criteria that ensure that minimum wages really lift workers out of poverty and promote upward wage convergence across Europe. I'm sure you'll have a lot of questions for us about that, but our assessment is that while the court has annulled those criteria are still binding obligations on a number of member states, because those member states have ratified an International Labour Convention, number 131, that includes those criteria. So a number of member states remain bound by those criteria, even if they have been annulled by the court today. So in summary, the directive is solid. It needs solid implementation. Workers need real pay rises. We know how much workers are struggling to make ends meet. And I know for any minimum wage worker watching this, it's very important to them to hear the message very clearly that statutory minimum wages must increase in Europe to the level that's adequate, and that workers and through their trade unions can continue to push for that. The court did not deny that as an objective of this directive. Europe must make sure that every worker earns a wage that meets the threshold of decency, and that every worker has the right to collective bargaining. It's the only way to have a fair wage, that their right to collective bargaining is both protected and promoted. So today's ruling isn't the end of our struggle, it's a foundation for our progress. And it's proof that the work that the ETUC did in the preparation of this directive and during the time that it went through the different institutions, that it was grounded on fairness, fair wages, respect for workers, and importantly, that the EU would stand up for that and not against it. Thank you.
So we will be taking questions now. For the questions, we would like to ask you to raise your hand within the chat. Please introduce yourself by saying your name and the press outlet for who you are covering for. And if you could also turn on your camera, that would be appreciated. We'll start with Maria Psara, please.
Hello, I'm Maria Psara with FC Newspaper Greece. One general question first. You said that you need now the solid implementation. If I'm not wrong, most of the countries have already implemented this directive. I would like to know what is solid implementation, because as far as I know, the right implementation goes only with some countries, if I'm not wrong, not more than 9. And I'm coming now to the second question. I'm taking you to Greece. I would like to know if Greece is one of the countries that the 80% of the working people do not have collective bargaining. And to finish, a comment, please, on the 13 hours of work that now it is legislated in Greece. Thank you so much.
I'm going to ask my colleague Isabel to give some of the details, but the headline numbers are that a number of member states have still not implemented or still have not transposed the directive at all, and then in other circumstances they haven't taken the step towards having the action plans, even though they're obliged to do that because they're below the 80%. But I'll ask Isabel, who's done a lot of the research, as to the extent to which the transposition really matches what's needed. Isabel, over to you.
Thank you so much, Esther, and thank you for your questions. What we have, thanks to a very important project, the Wager project in the ETUC, is that 19 member states have already transposed the directive. We have 9 front runners who have indeed transposed the directive in a way that is, I would say, satisfactory, but of course, depending on the national situations. We have 10 member states that have done the minimum, which is, of course, either cutting pace the directive, or even saying that the level of the national situation is satisfactory. And we still have 8 member states waiting for transpositions. And of course, where it is important is, of course, to see where some of those member states have, for example, look into having an action plan, as you were referring to. And for the moment, we are having indeed 4 member states who have launched an action plan to promote collective bargaining. And this is Lithuania, Latvia, Czechia, and Ireland. Back to you, Esther.
Thanks. Now we will go to Laura Ingemarsson, please.
Hi, Laura Ingemarsson with the Swedish outlet ETUC. First, I'm sorry, I don't really understand everything. I'm trying my best. And it's been quite a lot of confusion. One Swedish MEP described this as a huge win, saying that the Commission now needs to annul parts of the directive and that the Commission has this complete overreach, when another MEP is saying that the Commission doesn't have to back at all. So my question is, does the Commission need to annul any part of the directive? And my second question is, does Sweden need to do anything legislative? Will anything happen with Swedish law?
So the court annulled part of the directive, and the part that the court annulled is part of Article 4 of 5. Part of Article 5 is Article 5.2. And what Article 5.2 does is it established criteria that member states were obliged to use to establish whether their statutory minimum wage was adequate. So Sweden doesn't have a statutory minimum wage, and so it had no obligation to use those criteria, because the criteria only applied to statutory, the adequacy of statutory minimum wages. So what has been annulled by the court is the provisions that required member states to check the purchasing power of their statutory minimum wages, to check the general level of wages, to check the growth of wages, and to consider productivity. So those were the criteria that member states were obliged to assess. They're no longer obliged to assess them, but most member states do and will. They did before the directive was implemented. Those criteria are in the International Labour Standard 131, which most member states, I think it's 11 member states with statutory wages, have applied. So that's what the main thing is that the court has done. It's done one extra thing. And the other thing that it's done is that the directive included a safeguard. The directive said, if you use automatic indexation to increase your statutory minimum wages, you cannot use automatic indexation to decrease your statutory minimum wages. And what the court has said is that the EU cannot put that bar on reducing statutory minimum wages by means of automatic indexation. So it removed that safeguard. But to be honest, I had a conversation with colleagues, and none of us, even though some of them are even older than me, could remember any time where a statutory minimum wage had been reduced because of indexation. So it's not something that has it's not something I expect to have an impact.
But it could now technically happen then that you decrease minimum salary.
No.
Okay.
No. The court in its ruling never said that. And if the court meant for that to be the implication of this removal, it would have said it. It didn't say that. What it said was that the EU cannot protect workers from member states if they choose to do that. But in no way, at no stage does the ruling suggest that such a thing should be done. In fact, just the opposite. There's another provision that wasn't removed in the directive that says member states shouldn't use this directive as a reason to reduce or go backwards on statutory minimum wages. So in my assessment, it would be a massive, massive over-interpretation, an incorrect legal over-interpretation to say that this ruling means that statutory minimum wages can be reduced. It doesn't. It didn't say that, doesn't say that. It just said that the EU cannot have a law that prevents a certain type of mechanism being used by member states if they choose to.
Thank you. So nothing will affect Sweden really in practice.
I can't see what it would, because Sweden doesn't have a statutory minimum wage, so I can't see any impact.
And now we will take the next question from Rani Beck.
Hi, Rani Beck from Bruxelles and Omegn. I would like to ask you, how was it for you when the only support from Denmark was from a yellow union? How does that feel?
So I don't, Rani, I have to be honest, it's good to see you again, but I actually don't know anything about that union, so I can't, so nothing I can say about who said what in Denmark, and apologies about that, but what I can say is what the ETUC is saying. So the ETUC is very clear in saying that what this ruling does is it confirms what the trade unions in Denmark called for, which is a very clear recognition that their well-functioning system is not in any way damaged or impacted by the Adequate Minimum Wage Directive. So it confirms that for sure, puts it beyond question.
Thank you.
Next question from Carl von Schiele.
Yes, hello. I'm also working for Swedish media, a union paper called Arbetsvärlden, the word of work, perhaps in English. I have one question, and that is, how do you view the fact that Swedish and Danish trade unions have been at the forefront of efforts to block the directive of minimum wage, which 25 of the EU's member states have supported?
My assessment is that the colleagues there were seeking an assurance that their well-functioning system couldn't be damaged. And it's understandable that they would do that, given that in the past, for example, the Laval ruling, or there have been other rulings in the past, and they were cautious and conscious and wanted to get sufficient assurance, and they went to the court to secure that assurance. And as far as I can see, and my assessment is that this ruling gives them that. I don't know if you want to say anything more about that, but that so that's my assessment. I've seen the press releases from the colleagues in LO and the colleagues in FH, of course, and their assessment is that the court, the ruling confirms that they're that there doesn't need to be any changes whatsoever to their well-functioning system from this directive.
But is it a problem for ETUC that two important members organizations, or more than that, are confronting your view of this in this matter?
No, so no. It's, I mean, we're Europe-wide. Often affiliates have disagreements in analysis. Often we have differences in view and interpretation, even within member states. But I don't see that and often at meetings, everybody's stressed. Everybody in the ETUC stressed. Nobody wanted to damage the system in Sweden, nobody wanted to damage the system in Denmark, and there's nobody more relieved than me that they received confirmation of that in this ruling. What we need to do now is to work together to make sure that everybody in Europe has the right to collective bargaining, and that collective bargaining is recognized by employers everywhere, not just in Denmark and Sweden. So if you like, and I know that the colleagues in Denmark and Sweden are equally want to make sure that workers everywhere can join a union and have their right to collective bargaining properly recognized. So there isn't that much disagreement. Like a lot of people mention to me about disagreement and division, but I have never experienced it in that way.
Okay, thank you.
Thank you, journalists. I do not see any further questions with no hands raised, so we will bring this press conference to a close. Thank you very much. Goodbye. Faut fermer l'appel.